15 years of experience in the MENA region. Rasha specializes in intellectual property rights with an emphasis on trademarks and copyright. She advises both local and international clients across a range of sectors. We also have Aida Al-Jahami, who is an associate at Al-Tamimi. She qualified as a Romani lawyer in 2020. Aida handles intellectual property matters, advising regional and international clients on the protection of their trademarks and patents.
Good morning, everyone. Thank you so much for the ministry for having us today here. And it's really good to see a good number of people attending. So this is really, it's a good feeling, to have this number of people attending the session today. Thank you for the introduction. And I'm not going to take a very long time in introducing, but today the session is going to be about intellectual property. And intellectual property is a term that so many people hear of it, but it's not necessarily that it's every time. Okay, one second, can you hear me well? Okay. So it's not a term that it's usually understood. When I started to do intellectual property, every time I say it, I think it's right.
Yeah, because it's recorded.
Okay, is that better?
I think they use it for the recording for the YouTube video.
Okay, so that's fine. Okay. So yeah, when I started doing intellectual property, every time someone asked me, what type of law you're doing, I would say intellectual property. And then the second question come as how is the property market these days? And I'll be no, it's not this property. It's a different type of property. I think at the beginning, it wasn't really very much of an understood term, or what does it mean as an intellectual property. But nowadays, it is more and more understood because now in all of our lives, the intellectual property is there. Intellectual property, basically, it is actually the creation of the mind. Anything that the mind of a human can create, this can be an intellectual property. There are some rights that are related to this intellectual creativity, and this is where the intellectual property comes in. So anything that the mind may create, this will the person who created it can have rights over it. It becomes extremely important, the intellectual property, because it has become in every aspect of our lives. Whatever you see around you, you will see there is some kind of intellectual property right that it is attributed to it. It started at a very, let's say, a long time ago. And it's related to, for example, let's say the writing, as copyrights and neighboring rights. It started for the a long time ago with the trade. People started to put engraving on their products, and this started where it started for the trademarks, for example. So we're talking about rights that are really goes back to a very, very long time in the past, but with the time it becomes more and more increasing. There are studies that says that almost 80% of companies' assets nowadays are actually intangible assets, which includes the intellectual property. So we're talking about a huge assets that has incredible value, and that's why it should not be actually overlooked, and people should actually pay more attention to it. Intellectual property rights, it has let's say, it has been regulated on a different levels, whether it is the national level or the international level, and we're going to talk about this at a later stage. The idea behind the intellectual property and why there are rights related to it, the idea is to give kind of an incentive to all the people who create things. Whoever comes up with great ideas, we're giving them kind of an incentive to continue and do this creativity, to continue to create, to continue to innovate. So they get like kind of an incentive which gives them the exclusive rights over what they have created. So this is kind of an incentive that gives to the creators, but at the same time, there is a need to have the community and the world utilize all these creations or all these innovations. So with all the intellectual property laws, there is always kind of a try to do a balance between the interest of the people who created the rights and the right of the community and the right of the world to continue with the innovation and the creativity. That's why most of or all of the intellectual property rights are limited with time, so that the owner can get the incentive or the creator can get the incentive, but at the same time we allow later the world and the community to actually use these intellectual property rights. So this is just like, in a nutshell, what is intellectual property rights. There are, of course, different types of intellectual property rights. What you can see in front of you is a list of, let's say, most of the intellectual property rights. We have trademarks, we have copyrights, patents, utility models, industrial designs, trade name, domain names, geographical indications, and trade secrets. These are all intellectual property rights. These are the different ones that are available. The most common and the rights that we hear a lot about are usually the trademark, copyright, and patent, the first three. Trade name and domain names are not specifically intellectual property rights on their own. They are actually related to trademarks because it is actually linked to a trademark. So you do not see it as a separate intellectual property, but it becomes more and more important by the time, especially the domain names where everyone now has a domain name, has a website. So it's extremely important, but it is always linked with the trademark. So it's not like an intellectual property right on its own. What else? Yeah, geographical indications. And geographical indications, in our region, it's not really very popular. It is maybe popular in other countries, but in our region, it is not really very popular. It is basically what you call it, like, if there is a product that is produced in a certain area, and it is linked to that area specifically. Like, sometimes the types of cheese, because it is only created in a certain area, or it was actually created at the very beginning for protecting some types of champagne, because the grapes grows in certain areas. So the protection is related to it. But let's say it developed. Like, for example, we all know the Swiss watches. The Swiss watches, it is always known for high quality, high accuracy, luxury sometimes. So the term Swiss has become a geographical indication as well for watches. So not any company can, for example, use Swiss watches unless these watches are actually manufactured in Switzerland. So this is kind of a protection for the geographical indication, because it will cause confusion to consumers, because people would want to buy a Swiss watch because of the quality that is indicated with the country. Trade secrets, it's again another intellectual property that is getting now more and more important in our region. It hasn't been before, and it is not regulated in most of the countries. I think there is just a handful of countries in the region that has actually laws protecting trade secrets. It is always confused with confidential information, but it is different than confidential information. it is actually a confidential information, but it does have other, let's say, criteria to qualify as a trade secret. So not every confidential information is a trade secret, but every trade secret is a confidential information. The most popular example about trade secrets is the Coca-Cola recipe. This is known to be the most expensive trade secret in the world. The formula is actually protected in a bank, in a safe in a bank. And there are only 2 people from the Coca-Cola company who has access to this formula. These 2 people cannot go in the same plane, or they cannot be both in the same risky situation, because like we need one of them to get access to this formula. And this is actually one of the reasons for the success of the Coca-Cola. It's the formula. Now everyone would say, yeah, but it is already mentioned on their bottles. Well, it's not mentioned on their bottles. Like, all the products has the same ingredients, let's say, like, water, sugar, and like, whatever is the ingredients that it's there, but the formula and how they come up with the taste of it, this is the trade secret that no one knows, and it has been protected and kept secret for a very long time. The other one is the KFC recipe. Again, it is one of the most valuable, let's say, trade secrets. Again, it is a recipe that no one knows. It is protected as secret, and there is very limited people who has access to it. For trade secret, it's very interesting that in order to be protected, you have to keep it secret. So this is the only requirement. You have to keep it secret. If you just let different people have access to it, then it's no longer a secret. So you don't have to do anything but to keep it secret, and then you get a protection for a trade secret. So these are the main intellectual property rights. In our session today, we're just going to focus on trademarks, and we're going to focus also on copyright as 2 of the main and most, let's say, talked about intellectual property rights, especially in our region. We're going to start with the trademarks. As you can see in front of you, there are a number of brands, or like, let's say, logos, and I think all of you know them. These are the most valuable brands in the world. Every year, the Forbes, they issue like a list, a report of the most valuable brands across the world. And these are on the top 6 brands in the world. The number 1 is Apple. Apple value is $241 billion US. This is the value of the brand itself. If we talk about Google, is $207 billion US. Microsoft, $162 billion. So we're talking about, like, a huge amount of money that is reflected on only the value of the brand. We're not talking about anything else in the company. We're just talking about the brand itself. And that's why it becomes like an absolutely important asset. So if you want to sell the Apple, there is a huge amount that is reflected in the brand itself. Apple, maybe without the brand, it's just a company that sells, electronic devices. Yes, of course, there is a huge value in the, let's say, in the quality of the products that they create. There is a huge importance of the technology that they use, but at the end of the day, most of the people buy it because it's Apple. If the logo is removed from the product, you will think twice before buying it. But because immediately when you see the Apple logo, it gives you a kind of direct information on the quality of the product, where is this product coming from, and it immediately not attracts you, it makes you buy this product because of the brand that it is put on it. Of course, the value of these brands didn't come in one night. It is like, it's a long time of consistency in terms of the quality and the spend on the marketing and all of that, put this product or put this brand in this position to become the #1 brand across the world in terms of the value. So with this importance, we have got laws that protect the trademarks and provide for the let's say the enforcement of the trademarks, where why no one shouldn't make a product or a trademark that looks like the apple. I'm going to now hand over to my colleague Aida, who's going to take you now through the trademarks law in Oman and to talk about how we protect this trademark, how we reach to brands that could be valuable the same as these brands. Thank you.
Good morning, everyone. So we're going to start with the legal framework of trademarks in Oman. As my colleague Rasha has mentioned, legal framework is essential in brand protection. Legal protection allows its trademark owner to enforce its rights over its trademarks and control who can use it. And it also protects the business owner against reputation damage. So let us start with the legal framework of trademark laws in Oman. So here we have the laws. The main law of trademarks is Royal Decree 33 of 2017, promulgating the law of trademarks for the GCC states. Now, Royal Decree 67 of 2008, promulgating the law on industrial property rights, is only used for trademarks if there is a section that is not covered in Royal Decree 33 of 2017. And anything that goes against Royal Decree 33 of 2017 is repealed. We also have regulations against trademark, which is regulations for trademark, which is Ministerial Decision 105 of 2008, promulgating the implementing regulation of the industrial property right law. Oman is also a part of several treaties in trademarks, which includes the Paris Convention, the Madrid Protocol, the Trademark Law Treaty, and the WIPO Convention. Now, the competent authority to register your trademarks is the Ministry of Commerce, Industry, and Investment Promotion. What is a trademark, and how is it a valuable asset to businesses today? Can anyone tell me what a trademark is? Anyone has a clue of what a trademark? Anyone wants to try? Give me a definition of a trademark. Okay. Yeah, exactly. So a trademark is a word, symbol, slogan, packaging, or a combination of these that is used to distinguish goods and services to other goods and services in the market, and it is protected by intellectual property rights. Now, as my colleague Rasha mentioned, trademarks is not something new. It is something that existed since the ancient time. And to prove ownership, artists, they used to mark on their trademark. But today, because trademarks is seen as a very valuable means in developing a business, gradually laws and regulations started to appear around it. There are also non-traditional trademarks that I'm sure many are not aware of. These include sound, color, fragrance, and motion. So I'm sure you all know the sound of this. I don't know if... do you know the sound of this? This is a protected... Does anyone recognize the sound? Yeah, exactly. There are also other kinds of marks. Now take note that trademarks are not just used to distinguish goods and services to other goods and services, but they can also be used as collective marks and certification marks. Now, collective mark is used to illustrate that a person is part of a member of an association. Let's say we have CPA, we have ACCA. So let's say if someone puts ACCA in their resume, it means that they're part of the ACCA member association. The other one we have is certification mark. Certification mark is actually put in goods and services that illustrates to the consumers that this good and service meets a certain health standard. Okay. So now let us see the definition of trademarks under the Omani trademark law. It is everything that takes a distinct form, such as names, words, signature, characters, or any other sign or group of signs used or intended to be used to distinguish goods or service of one business from the goods and services to other business, indicate the provisions of a service, or indicate control and inspection of goods or services. Now, what is the purpose of having a trademark law? Of course, having a trademark protection, it is to avoid unfair competition in the market, and it also sets barriers so third parties do not copy your goods or services, and you eliminate counterfeit products being in the market. So what are the functions of a trademark? Let's say we have a trademark, we have a logo that for our business and service. For our goods and services, what is the function of it? The function of it is that it indicates the source or origin of goods or service. It assures consumer of the quality of goods bearing the mark, and it creates business goodwill and brand awareness. Now, one common misconception that I want to make you all aware of is when we have our trademarks and when we protect it, we straight away believe that our trademark is completely protected from any use, but actually a trademark is only protected for certain goods and services. And that is why when business owners want to create a brand, they should create a very strong brand, a brand that is more distinct and less generic. And now I'm going to illustrate to you how you can build a very strong trademark. So I'm going to go through the 4 steps of building a strong trademark. The first thing, obviously, you have to do is choose a mark. The second thing, once you choose a mark, don't share it with anyone, but go and protect it straight away. Go and protect your mark. And once your mark is protected, you maintain and use it properly. And once it is protected, you also can enforce your trademark rights. So selecting a mark. How can you select a mark? As I said, to build a strong trademark, it has to be more distinct and less generic. Okay, so building a strong trademark is very important in your brand. So let us start with the strong trademarks. The strong trademarks is classified as fanciful, arbitrary, and suggestive. Now, what is a fanciful trademark? Fanciful trademarks such as Häagen-Dazs. Häagen-Dazs, it doesn't have a meaning, but it has a meaning to its goods and services that it provides. So it is distinct. It is a distinct trademark, and because the trademark doesn't have any meaning you need to educate the public on how your trademark is linked to your good and service. Other example is Google or Rolex. If today I tell you I'm going to get a Rolex, you surely know that I'm going to get a Rolex watch. The second one we have is arbitrary. Arbitrary we have is like Apple. That's not the Apple we eat, but that's Apple that's linked to MacBook. Okay, so arbitrary are, again, they don't have a meaning, and they're actually not even associated with the good and service. However, it is highly distinct, and it is also at the end of the spectrum. It is highly distinct, and it makes it hard for counterfeits to appear in the market for arbitrary. Yeah?
Just allow me.
Yeah.
Why we're talking about the distinctive spectrum is that because the at what it means to be distinctive. The distinctiveness means that it does not describe the product. It is not the generic name of the product. It is just a word, or it is just as I mentioned, like logo, anything that would make your product stand out from the products of the other people in the market, or the service that you provide is from the services that are provided by other people in the market. So that's why we're talking about the distinctiveness spectrum. This is very important in trademarks because this is what decides that your trademark is protected or not protected. The strongest is when you go to the left side, which is, as Aida mentioned, it is the
Fanciful.
The fanciful, it is something that doesn't have any meaning, basically. It's just a come-up word. It is, as mentioned, the Häagen-Dazs, for example, Adidas. These are not, it's words, but it doesn't have a meaning, which means, like, if you open the dictionary, there is no word that would say Adidas. It's not there. But when you go to the arbitrary, it is a word that has a meaning. For example, the apple. It does have a meaning. You go to the dictionary, there is something that is called apple. But why it came at the, let's say, the distinctive or the highly distinctive trademark, because it is used for products that are not apples. So it is basically, it is used for something else. It is used for electronics, which is not at all relevant to the food or to the apple. So that's why it becomes like very distinctive, and we consider it from the trademarks that are extremely distinctive. So whenever the trademarks becomes generic, it means it doesn't have protection. Like, for example, if you call like the water product, you call it water. It's not a trademark because everyone has the right to call the water as water. And when we talk about generic and we talk about descriptive, and Aida will continue now, the idea of having it distinctive is because at the end of the day, when you have a trademark registered, you have exclusive rights, meaning you are excluding everyone else from using it. That's why no one can register water for a water product, because everyone has the right to use it. You cannot prevent someone from calling the water water. So that's why it's a generic term and it cannot be protected. So that's why we're talking about the distinctiveness, because it is the only condition for a trademark to be registered and protected.
Exactly. And then we have suggestive. Suggestive is basically, it suggests to the consumers what the product actually is, but it doesn't describe it in great detail. So for example, we have Burger King. Another example would be Netflix or Airbus. Unlike arbitrary and fanciful, for suggestive, you don't really need to educate the public on how your trademark is associated with your goods or service. And then the last two we have is descriptive and generic. These are less distinct, and in most instances, they're not capable of being registered. Descriptive basically it describes what the goods and service is, and the trademark and how the trademark is linked to the goods and service. For example, we have American Airlines. Now, descriptive trademarks generally are not accepted unless they have a secondary meaning in the market, unless they gain extensive reputation in the market. For instance, another example we have, other than American Airlines, is Holiday Inn. So because Holiday Inn did gain a reputation in the market, that's why it is capable of registration. And then the last one, which is at the end of the spectrum, is generic trademarks. Now, generics, they're common words. Generics are not capable of being registered. And because no one has exclusive rights over common words. Okay? So this is how to choose a strong trademark. Now let me ask you: are these capable of registration? Can anyone tell me? The Oman flag, is it capable of registration in clothing? No. Okay, Mecca for Islamic finance products. Yes? No? Maybe? No. Swiss Delights for chocolates.
What did we get for Mecca?
They no.
Why not? We need a reason.
Geographical indication.
Geographical indication. What if it was like a bank in Saudi? That was issuing a credit card, like Islamic credit card that is called Makkah.
Creatively designed with another word style or something can be registered. But if the word itself, the standard word, will not be registered.
So if it was with a design, it can be protected?
Yes.
Okay.
Isn't it have too much cultural significance for it to be, maybe it's like considered offensive to use it as a product?
I don't hear anyone talking about to register country. Well, that's correct. Well, you know, some of the answers are right. The idea, there are too many things actually with the Makkah. As you mentioned, it is a geographical place. It's a place that, you know, you cannot register it unless you are from that area. Specifically, you are in that country and your products are from that country. But for Mecca, for this one specifically, there is something in the law that prevents specifically the registration of religious symbols.
Yeah.
Mecca on its own is not, you know, a religious symbol, but it is actually, this was an actual case that we had, but the court decided that it is an actual religious symbol and no one can register it. If we, you know, negotiate it, or if we, you know, look into it, it's not, you know, Mecca is not the symbol itself. Maybe Al-Kaaba is the religious symbol, but the court decided that no, Mecca, no one can register it because it is a religious symbol.
Yeah.
Usually, any religious symbols cannot be registered by the law. It is like, you know, we have certain prohibitions that are provided by the law where no one can have.
Yeah, and George Clooney for perfume. Is it registerable? Can you register George Clooney for? Yes? Exactly. Yes?
George Clooney can register.
Yeah, so,
George Clooney himself.
so I have a question. What if someone writes George Clooney, for instance? Is this debatable? Can someone challenge it?
George Clooney.
Well, okay, well, there is, I will tell you something, and we will talk about that when we talk about the enforcement of trademarks. The nice thing about trademarks is that the protection is not for the identical trademark, because the protection is for the confusingly similar trademarks. So if you change one letter, it doesn't mean that you made a distinctive trademark. It's still prohibited. For George Clooney, it is, although it is the name of the actor, but in any ways, like, you know, the names of the people cannot be registered unless it is the name of that person or with the approval of that person. Actually, we have so many cases like this. For example, most of you, I don't know, maybe knows Christian Louboutin, the designer who did, like, you know, shoes, and I think Aida, we're gonna share
Yeah.
some things. Christian Louboutin is the name of the designer, basically, and he tried to register his trademark under the name of his company, and it was rejected because it has to be registered under the name of the person himself, because this is a personal name. In some countries, it is allowed when you show the relationship between the company and the name of the person, but in general, it is not allowed to register the name of the person unless you are that person.
Yeah.
And this actually creates a lot of problems in our region because we do have lots of family businesses, and you know, the family businesses, they all use, you know, their family name. For example, our firm is called Al-Tamimi, and in Saudi, for example, there is a huge business for supermarkets that is called Al-Tamimi as well. So it's fine, you know, for different people to use their names, because at the end of the day, it is the name, it is their actual, you know, last name. It creates a lot of problems because there could be, like, you know, two people from the same family. So this is where you would need to add some additional distinctive names or, like, you know, logos to distinguish yourself.
Exactly. And so the next slide actually will take us to what are the prohibited trademarks under Royal Decree 33 of 2017. As you can see, it's generic names or non-distinctive marks, marks violating public morals and public orders, religious symbols, flags or national and international flags, name, picture, or logo of persons, mark causing confusion or containing false origin or carrying a forged name, marks containing title of owner which cannot be proven, well-known marks, and marks containing words such as privilege, privileged, registered drawing, or copyright. So these are all the prohibited trademarks that's available under Royal Decree 33 of 2017. Now, our second aspect in building a strong trademark is to protect it. So once we choose a distinct trademark, we proceed in protecting it. And how do we do that? By trademark registration. Who is eligible to register a trademark? Now, any natural or legal person residing in the GCC or a foreign country that is engaged in business activities eligible to register a trademark. Also, government entities are eligible in registering a trademark. Now, an important question, can individuals actually register a trademark? In Oman, the practice in Oman is that they will allow sometimes for individual to register a trademark, but when you're registering a trademark in Oman, they do require a trade license. Okay, so they do require proof that you are actually engaged in a business. So I'm sure you all know Ministerial Decision 473 of 2022, which is homemade businesses, they now require a license. Yeah? So now this is something to think of. You know, this ministerial decision encourages those home businesses to actually get a license and to protect their brands. Because like I say, in Oman, individuals, it is very hard for them to protect their brands. And I'm sure we all know that a lot of, we have a lot of Instagram pages and a lot of brand owners in Oman, but they don't actually really have a trade license. Okay, now the procedures of registering a trademark in Oman, there are 5 simple procedures, 5 simple steps. The first step is trademark search. Now, trademark search is not a mandatory step, it is a recommended step. Why is it a recommended step? Because when you conduct a trademark search, it ensures that your trademark procedure goes smoothly. And it's also your the examiner basically checks whether your trademark is similar to any other trademark, whether it's distinct or whatnot. And so it advises you before you proceed to the next step. Once you pass the trademark step, you go to the trademark application. Trademark application, it's basically a very standard trademark application. When you're filing for a trademark application, you need to focus on what your business is running. So let's say your business is in the cosmetics. It's selling cosmetics, okay? It's providing cosmetic goods. You will need to focus on which NIS classification to register your trademark in. Okay, so for instance, classes 1 to 34 is for providing goods, and classes 35 to 45 is providing service. So let's take, for example, we're in the cosmetic business. We will register our trademark in the NIS classification 3. This will be the core class because NIS classification 3 covers cosmetics. Okay, and now the wider your trademark protection, the better it is for you. And therefore, we always have preventive classes. Preventive classes are basically where can your business register its trademark in, like. Let's say it will be advertising, it's cosmetics. So it is also better to register it in class 35 because class 35 is to do with advertisements. So when you're registering your trademark, it is very important to determine the correct NIS classification. And then other standard documents that they ask for is the power of attorney if you're representing a company. And of course, it has to be certified and legalized, and your trade license. or commercial registration certificate. If it's for anything to do with a foreign company, of course, it has to be certified and legalized. Then you go to the examination. Now, once you submit your trademark application, it goes immediately to examination. Usually, the examiner examines your trademark on a relative ground and absolute ground. Absolute ground is they check whether your trademark is distinct, whether it's generic, whether it's descriptive, and relative ground, it compares your trademark to other trademarks that are already registered in the market. Now, the examination period usually takes 1 to 2 months with the trademark office. Now, once your trademark is accepted, okay, it goes to publication in the official gazette. Now, why does it go to publication in the official gazette? Because it allows third parties 60 days to oppose against your trademark. Okay, now if your trademark is not opposed within the 60 days, your trademark moves to registration, and of course you become the exclusive owner of your trademark in the specific good and services. However, what if your trademark application is rejected even before it goes to publication? If your trademark is rejected, of course the applicant has 60 days to appeal before the trademark committee's office at the trademark office and the intellectual property department, the Ministry of Commerce. And if that decision, that the appeal is rejected again, you can resort to the courts. You have 60 days to resort to the courts. And if you don't respond to the rejection decision, then your trademark will be considered abandoned, and you won't be able to proceed. Now, what if a published trademark is opposed? As I said, third parties have the option of opposing against your trademark. Okay, now if, let's say, your trademark is opposed, the trademark office will accept your opposition, and they will have a 30-day period to give the applicant the opposition. And then the applicant, once they receive the opposition, they have 60 days to respond to the opposition, failure of which considers their trademark abandoned. However, if the applicant does respond to the opposition within the 60 days, the trademark office, the trademark committee, they provide a hearing between the parties. Now, hearing is just exchange of counter statements. It's not an actual hearing, but it's just an exchange of counter statements. And then at the end, the trademark committee makes a decision, and its decision can be appealed by whoever is, by the party that's not satisfied. It can be appealed to the court. You only have 60 days to appeal to the court before the decision of the trademark office is finalized. Yeah? Yeah. Yeah, sure, sure. So, of course, reasons for filing a trademark opposition, it will be the most actual reason for filing a trademark opposition is because your trademark has been similar to other trademark in the same good and services. Okay, over here you can see McDonald's, McDowell. This is in the dining industry. Obviously, McDowell is copying McDonald's. And then you have Puma and Kuma. This is in the fashion industry. Example of opposition in real life. I'm sure you're all aware of MBC Action. Okay, so we represented MBC Action in an opposition case at the Ministry of Commerce. There was a company that infringed MBC Action's trademark. As you can see, Fast Action. It's similar, right? So we filed an opposition. The local company actually responded, and they said, no, our trademark is not the same. However, the decision was in our favor because the word action is very, very similar to MBC Action's trademark. Now, cancellation of actions, of trademarks. So cancellation actions, if you believe that there is an unlawful trademark registered at the trademark office, what you can do is you can resort to the court to cancel off the unlawful registered trademark. Now, a trademark can also be cancelled off if you do not maintain the usage of a trademark for a period of 5 consecutive years. Okay. Now, example of infringement cases. These are the global trademark infringement cases. I will quickly go through the Louboutin's Red Sole trademark dispute decision in CGEU. I'm sure you all know Louboutin and their famous Red Sole. Okay, so what's happened in this case? There was a designer, his name is Van Haren, who sold high-heeled shoes with the Red Sole, copying Louboutin's Red Sole shoes. So Louboutin filed a case against them. Now the issue here was whether the Red Sole is an exclusive shape that's not capable of being registered, or whether it is a position of the mark that is capable of being registered. Of course, the CGEU, they concluded that actually the Red Sole is not an exclusive mark. It is a position of a mark, and it is capable of being protected, even though the lower the lower courts did not agree with the CGEU's decision. So Louboutin won the case here because it was a position mark and it wasn't an exclusive shape. Yes?
Explain the position and trademark
Yeah.
means, like, you know, it is put in a certain way. So for the shoes, you know, the red sole is always, like, you know, it is the red sole. It is always in the bottom. We're not talking about the red, like, the shoes itself is in red. It is just, you know, the sole of the shoes. That's why they call it the position and trademark, because it is put in a certain place. So this red color now, like, no one can use a red color on the sole of any shoes because it is already protected as a position trademark.
Exactly. Now the key takeaways for these is it's a very important case for in the fashion industry, because now it will encourage, it will enhance the colors being a non-traditional trademark. Remember in my first slides I told you, like, trademarks can also be colors. Those are non-traditional trademarks. So it encourages the fashion industry to be creative, to use colors in their brands. Okay. However, not all jurisdictions agreed with the CGEU's decision, obviously. But for example, Japan, they view color as an exclusive shape. It is something common that not everyone can have rights towards. Okay. The third aspect, remember, in building a strong trademark, the third aspect was to maintain. So maintain, if you have a trademark, make sure you use it. Don't keep it abandoned for 5 years. Anyone can go to court and cancel it off. Remember to renew your trademarks every 10 years. Okay, and ensure that your portfolio is accurate, the correct name and address is mentioned in your trademark, and regularly conduct audits in the market to see whether there is any counterfeit products being sold which will damage the reputation of your business. The last one is we have is trademark enforcement. So once you protect trademarks, you have enforcement rights. You can enforce your rights over your trademarks. In Oman, the 4 enforcement options to enforce your trademark, we have 4 enforcement options. Number 1, precautionary measures, administrative action, criminal action, and civil action. The preventive measure, what is a preventive measure? Preventive measure is basically if you believe that if a counterfeit product is entering Oman, okay, and you immediately write to the Intellectual Property Department at the Ministry of Commerce, and the Intellectual Property Department, they get in contact with the customs, telling them that we suspect an infringed product or counterfeit product entering the Sultanate. So you should stop it from entering the market. Of course, the customs will assess the case, and if they find it true that indeed this trademark is a counterfeit product, they will stop it from entering the Sultanate of Oman. Now, of course, preventive measures cannot be used for small quantities, and they cannot be used for products that are already available and distributed in the market. Now, for products that are already available in the market, we have 3 actions to be taken, which is administrative action, criminal action, and civil action. Administrative action, this is a recommended step, it's not mandatory. So you can proceed straight away with filing a court proceeding without going through administrative action. Administrative action is carried out through the Intellectual Property Department at the Ministry of Commerce and Industry or the Consumer Protection Authority. Now, in the usual cases, the Intellectual Property Department, they review the file, they review the case, and and the infringement, and they will, if they did file a case, if they did find a case and they did find an infringement, they will call the other party and try to solve the case amicably. If he listens, okay, it's good, he listened. But if he doesn't, then the Intellectual Property Department, they have the right of transferring the file to the public prosecution. And administrative action is very efficient because it's quick, and it is less expensive as well. However, it is not efficient for a major distributor of counterfeit products. Then we have the criminal action. Criminal action, you file a complaint with the public prosecution. And sorry, yeah? We'll have a Q&A at the end where we can answer questions. Yeah. Okay, so the complaint is filed with the public prosecution, which would then be transferred to the criminal court. And this is the most effective manner to deter a huge amount of counterfeit products in Oman. The penalties for criminal action under Royal Decree 33 of 2017 is imprisonment of not less than 1 month and not exceeding 3 years, and a fine of not less than Omani Riyal 500 and not exceeding Omani Riyal 100,000. So let us make sure when we create a brand, we do not try to copy a very famous trademark in Oman or worldwide. So the remedies for criminal action is basically fines, destruction of the goods, and also jail time. The last one we have is civil action. Civil action is basically filed when we want monetary compensation. So civil litigation is increasingly used as a method as resolving IP disputes, particularly in cases involving more complex issues such as lookalikes of trademark disputes. The case can be filed with the first instance court, which is appealable to the Court of Appeal and the Supreme Court. The remedies of a civil action is seizing the goods involving infringement, obligating the infringer to seize the infringement, to seize the infringement, excluding the export of such goods, obligate the infringer to destroy all the goods without at their cost. And the infringer also has the obligation of informing the court on who are all the people that were associated in making these counterfeit products. And of course, you have the monetary damage, which is assessed based on the infringer's profit, the profit he made. This is how the monetary damage is usually assessed for counterfeit products. And now we will move. This covers our end of trademarks. Now we will move to copyrights, which my colleague Rasha Al-Arda will explain further. Thanks.
I think we don't have much of the time, but I'm just going to give like a bit of a brief about copyright because we promised to do that. Well, usually these topics are actually we do separate sessions for each one. we need a separate one for the copyright. But in a quick, I'm just going to explain what is copyright basically. Copyright, it is. It's a bundle of rights that are given to the creator of an original work. We give the person who create like a work, a certain work, we give them like, a number of rights that would allow them to use the work and to exclude other from using it. The copyright is, as you have seen, the trademarks, it's more of, logos, words, and that it's more related to the trade. For the copyright, it's a completely different story. The copyright protects a number of works that are so wide. It covers literary works, like, for example, books. It covers audiovisual works. So when we talk about movies, when we talk about songs, music, it covers as well software. So there is like a huge range of a product, or of works that are covered by the protection of copyright. The nice thing about the copyright is the criteria for the protection is very minimal. The only requirement to have a protection on any work is to be original. And the originality is very minimal again, which means that the person has created this work on his own or on her own, and not copied from someone else. This is the only requirement for the protection of the copyright. And unlike the trademark, where you have to register the trademark to get the protection, for the copyright you don't need to do anything. The minute the work is created, then it is protected. So you don't have to register, you don't have to do anything. The minute you compose the music, it is protected. The minute that you do this presentation, it is already there as a presentation, it is protected by copyright. There is no need for any registration. However, there is a mechanism that it's created for the let's say, for having an evidence of ownership, which is basically the registration, or what we don't call it registration as much as recording. You may record the work with the ministry, so that you get a certificate stating that you are the owner of this work. So it's very simple and it's very basic. There is no examination, there is nothing. It is just a way of having a proof of ownership. So when you have this copyright registration certificate, it's basically shift the burden of proof to anyone who claims that you are not the owner. You have a certificate saying that you are the owner of this work, so anyone claims otherwise has to prove it. That's why it is sometimes, recommended to have this certificate just for the sake of enforcement purposes. As we mentioned, there are a number of, for the laws, let's just talk about the laws quickly. We have in Oman the law number 65 of 2008. This is for the copyright and neighboring rights. There are also international treaties. We have the Berne Convention, which is the most important treaty that it's related to copyright, and it was since like 1800 years. So it is a very long time that it talks about the protection of copyright. These are the main laws and treaties that are related to the protection of intellectual property or of copyright. And as you have seen with the trademarks and with the copyright, there is always international treaties, and these are extremely important. There is also the TRIPS, I think it's not mentioned here. So the treaties are very important because they provide a kind of what we call the minimum level protection that is required for the protection of intellectual property in any country that is party to any of these treaties. So basically we have the TRIPS, for example, the TRIPS agreement, which is the trade-related aspects of intellectual property, which is related to the World Trade Organization. This agreement has put like the minimum protection required. So for Oman, for any other country that it's party to it, its laws must provide this minimum. You can provide higher type of protection, but you have to provide the minimum. For example, what Aida mentioned for the enforcement, which is precautionary measures, administrative, criminal, and civil, these are provided by the TRIPS agreement. So you have to have all these measures for the enforcement of the intellectual property. It is the same, of course, for the copyright. You always see this symbol, which is the C, and it is always used in different aspects. It is mentioned here in our presentation, and next to it, Al-Tamimi and Company. So what does that mean? It means that this material is protected by copyright, and the owner of it is Al-Tamimi and Company. What if the symbol is not there? Does that mean that it's not protected? No, it means it is protected. But the reason why we put this symbol is alerting everyone else that this is protected by copyright. This means that when someone copies this, they do not have any excuse to say, oh, we didn't know. No, there was a copyright symbol that it's there with the name of the owner. You see this everywhere, in books, you see it on all websites, you would see the copyright and the name of the company. This is very, very important just to give no excuse to anyone to say that we didn't know that there is a copyright protection. Okay, so we talked about that. The duration for the protection for the copyright, as we mentioned, it starts actually at the minute of the creation, and it lasts for the lifetime of the author and 70 years after his death. So it's quite a long period of time. The reason for that is that when it comes to copyright, the protection is not for works that it's really affecting the development of the word. If we talk about patent, for example, the protection which protects inventions, the protection is only for 20 years because we want the word to get use of it. We want everyone to continue the development. We want people to do more research and development. So the protection is very limited for 20 years only. But for copyright, the protection is quite high. And in Oman, actually, it is really high for 70 years after death. In most of the countries, it's 50 years. But it's fine, the minimum is 50 years. So Oman, and I think in the US as well, it is 70 years after the death of the author. And we always talk about the author as a person. That's why we talk about the death and the life of the person. These are, as we mentioned, different types of works that can be protected. These are mentioned in the law as an example. So you can, get things that are similar. It shouldn't be just mentioned there. You can see also architectural works as well. It is protected by copyright. So there is a huge amount of works that can be protected. On our daily life, every day, every second, we are creating works that are worthy of copyright protection. And as we mentioned, it just could be, the only requirement is the originality, that it's not copied from someone else. There is one important thing about copyright, is that copyright does not protect the ideas, it protects the expression about the idea, how you express this idea. This is what is protected, not the idea itself. So basically, and this is a difference from inventions and the protection of patents, because with the patent you protect a certain product and the idea itself, that you have come up with. This is what you protect. But with copyright, you only protect the expression of the idea. We always give this example, which is, Romeo and Juliet story. It's a story of two people who love each other, whatever. It has been done in 100 movies. It's the same story. It is the same line of story, but it has been done in so many different ways, in so many different movies. It's fine. No movie means that it is infringing on the other movie, because it's not about the idea of the story. It is about how you express it. It is different. The same comes for photos, for example. We all take photos. We can take the same photo, and we all have copyright on that photo. For example, if I take now a photo from here and Aida take photo from the same place, we may get a very similar photo, but I have copyright for my photo and she has a copyright for her photo. This is different. We are taking a photo of the same thing. Sometimes, nowadays it is, content creation is very important because of the social media and all of that. So you see so many people trying to come up with creative ideas to take photos. They try to actually take, let's say, exclusivity over these ideas of taking the photo, which is like maybe putting like, a bottle of water in a certain, angle and taking the photo. They try to say, oh no, I came up first with this idea. But the idea itself is not protected. If anyone comes up and do the exact same idea and put the water here and took a photo, he would be also the owner of that photo. So it's not about the idea. This happens also in advertising and TV ads. We usually see it. So many people try to say like, yeah, but this is my idea. I have created this ad. The idea behind everything is not protected. The protection is for how you express it and how you do it. For example, the TV programs. For example, من سيربح المليون, مثلا Arab Idol, and there are so many programs. It is the same idea. It is all the same idea, but it is done in a different format. This is all fine. No one can have exclusivity over the idea itself, but it is how you, at the end, execute this idea. This is what is protected by copyright. Okay. Can we protect laws, regulations, and court judgments by copyright? Of course, it's a written work. The law is a written work. It's drafted by people. So does the people who draft the law own the law or own the copyright over the law? Of course not. These are excluded by the law. The Mona Lisa painting, is that protected by copyright? Anyone has any idea? What do you think? It's a painting. That's a very famous painting for Leonardo da Vinci.
No.
Who was answering?
No?
No?
Yes.
Why?
The creator died a long time ago.
Sorry?
It's in the public domain.
Yeah. Correct. It was protected by copyright, but as we mentioned, the copyright has a duration, which is for the lifetime of the author and 70 years after his death. After that, the work becomes in the public domain. And what it means in the public domain that anyone can use it or anyone can utilize it. So now you can see the Mona Lisa painting being reproduced in many different ways. It is commercialized by many different people, so that is fine.